maximum number of people know much about this subject. So before getting into this, I have mailed you, or hopefully you people have your Bear Acts with you. So my target of the today's lecture is to make you clear about conceptuality of Bear Act and regarding concept of res judicata. So let us start with that. So what do you mean by the term res judicata? Let us start with this. What do you mean by the? So basically, if you see the res judicata, the term res judicata is used under section 11 of CPC. If you see section 11 of CPC, it uses the term res judicata. First of all, try to understand what does this term res judicata mean. Try to understand the section 11 is not basically the complete principle of res judicata. Res judicata is a doctrine. It is a very broader doctrine. If I make you understand, the word res means to stop, or judicata means judication, adjudication. That is known as litigation. Litigation. So basically, if you try to understand the literal meaning, literal term meaning of the word res judicata, the word res judicata means to stop the litigation. So basically, what is you are going to read, or what we all are going to read under section 11, though the term res judicata is written, but it is only one of the dimension of a doctrine. So res judicata is a principle. It's a principle, that is this is the principle of res judicata. Out of that, only small portion is given under section 11. So though section 11 uses the terminology res judicata, but the complete principle of doctrine of res judicata is not involved in it. You must keep in mind one thing. For example, I say res judicata basically is one of the dimension of doctrine of estoppel. So doctrine of estoppel itself is a bigger, broader principle. Out of this, that broader principle, the smaller part of that principle is res judicata. And out of this doctrine of res judicata, one peculiar type of res judicata, it's a one specific feature of this bigger doctrine is incorporated under section 11. So try to understand, though word section res judicata is always only given under section 10 or section 11, but this principle is not completely exhaustive under section 11. This principle is very broad. You find it under order 2 rule 2, you find it under ex parte provisions, you will find under section 14. There are so many principles, so there are so many sections which have incorporated with the principle of res judicata. So before entering into the concept, you must make it clear that what we are studying, what we are going to study under section 6 is only one of the dimension of this broader principle. Okay, let us go and try to understand which part, which dimension of this broader principle is provided or is incorporated under section 11 of CPC. So if you go into section 11 of the CPC, so if I talk about, so basically, if you talk about general principle of res judicata, so if I say res judicata generally, so it is based upon public policy. It is based upon public policy. And what is the public policy? What the public policy is that? What is the public policy? To bring litigation at rest. And all the provisions you find in anywhere in CPC or any other law, in local laws, which tries to stop the further litigation or which try to bring rest upon the litigation, they are one of the dimension of the principle of res judicata. And in similar way, the one dimension of this broader principle is being given under section 11, though they use the term res judicata as general, but this is not the complete doctrine. It is one of the dimensions. So let us go under section 11 and try to find out what is the dimension. So I want to give a reading of section 11. Hopefully you people have the BEAR Act, and we give one reading firstly, and we'll then later on move into what this one word by word to the BEAR Act. Section 11 says, no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a formal suit between the same party or between party whom they or any of them claim, litigating under the same title, in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided. What they basically saying? They're saying, if you try to understand generally, section 11 says if suit, or I say issue, decided by court once, it cannot be decided next again. It will not be raised. It will not be raised again. What does it mean? Suppose, example, take out an example. Suppose A and B have a suit in year 1989 decided. They have a suit in 1989 and decided. This now A and B again want to file a suit. Want to file same suit in 2009. Can they do so? Answer is no. Not allowed. This is a basic general principle of res judicata. Broadly, I am speaking. Broadly, this is saying, section 11 is saying that the matter which has already been decided cannot be raised again. So something which has already been decided in section 1989, you cannot be allowed to do again in 2000. And this is general. We will talk in detail later on. We will go into BEAR Act one by word by word. But if you talk about general principle, this is what the general basic norms is saying, that suppose something is being litigated, decided somewhere early in year, and now again the parties are willing to bring the litigation into motion, again they are not allowed to do so. This is the broader general principle incorporated under section 11. But how this principle function, how this bar is being created, will be used by the court or the party, we have to understand. Now let us go into section word by word and try to pick it up one by word, what this is saying. So have you understood the basic philosophy of this act section? The basic philosophy of this section is this: see, once any matter is decided previously between the parties, you are not allowed to raise it again. Now we'll pick up word by word. No court shall try. I'm letting BEAR Act for you. I'm trying to explain the words for you first, and we will then bring all together in one page. No court shall try. What do you mean by no court shall try? That means section 11 creates the barrier upon the trial of the suit, not upon the cognizance. The courts are stopped to try under section 11 if the principle of section 11 are fulfilled. If the terms and conditions of section 11 are fulfilled, the court cannot try. When I say what is the difference between cognizance and trial, what I am trying to say, what section 11 is not stopping you to file a suit. So suppose A and B have a suit as one decided in 2000. and now they are filing A and B filing again suit 1 only, same suit 1 in 2009 filing. Section 11 is not stopping this filing. This filing is not being stopped. They can file. They can file. Try to understand. Before, what they are stopping is a trial. What section 11 is stopping is a trial of the court. Trial is being stopped. When I say trial, trial is you have to understand the stage. किसी भी सिविल सूट की अगर स्टेज को समझने की कोशिश करें तो सिविल सूट passes through certain stages. For example, you will file सबसे first stage you file pleadings, and these pleadings will be raised as an objections. Preliminary objections come. So there are preliminary objections which come. Right. After the preliminary objections, first date will be fixed in a court, and after this date, preliminary issues decided, and this is how preliminary issue decided, and this is how now main issues framed, and after this framing of issue, trial is start. It is the stage where trial is start. This is a stage where section 11 come into play. Try to understand. Section 11 came into play at the stage of trial. That means it stops court to function beyond this. So till preliminary issue, so you can file a suit. You can file suit 10 times, 20 times, 30 times. No issue. They are not saying you cannot file. That nobody can stop you to file a suit. But once you file a suit, and if court get to know through parties that this suit is being decided priorly, or this suit has been disposed of priorly on merits, then that court will not be allowed to do the trial. This is an absolute bar, but absolute bar is created upon the trial, not taking the cognizance of the suit. So nobody, section 10 will never stop the jurisdiction or bar the jurisdiction of the court. Section 11 is not a bar upon the jurisdiction of the court. Rather, it is bar upon the trial. So it creates a bar upon the trial firstly. Secondly, let us move forward. The no court shall try any suit or an issue. Second stage is no court shall try any suit or issue. This is the second situation of the application of section 11. Section 11 applies both on suit and issues. Both on suit and issue. When I say it applies both upon suit and issue, what does it mean to say? First, let us pick up the suit. For example, A and B have a litigation. This is a litigation, complete suit decided in 2009. Now A and B cannot file same suit in 2019. This is one thing. This is one thing. Same suit cannot be filed again. This is how the application. Same suit not allowed. This is the first thing. So it applies upon complete suit, complete right that has been raised by the party. But sometimes it happens in this way also. Try to understand. A and B having a suit which is having issues 1, 2, 3, 4. Okay. These are the issues. Issues in the suit. Suit is already going on. There is issue in the suit, and out of these issues, court decided these two. So out of so many issues, there are so many issues in the suit. There are so many issues in the suit. What do you mean by issue? Issue means it can be issues are of three types: issues of law, issues of fact, and issues of law and fact. For example, let us design a suit. That is design an issue. For example, breach of contract. Suppose this is a breach of contract. A and B have a suit upon breach of contract. What will be the issues in this breach of contract? There will be issues of law. First, what is the issue of law? Do contract that applies? Do Indian contract apply? Contract applies. एक issue बना. Let us do one issue. Second is, do barred by law of limitation or not? Barred by law of limitation. This is two law issue. Then there will be two factual issues. Suppose, what is a factual issue? Do there is a breach of contract? Breach of contract, or is it एक issue or one more issue that will be there? Do they have a contract? And so on. So let us talk about these issues. So, and we are having a suit having these four issues. These are the issue in a suit. In 2009, this is going on. Court decided these two issues. Court decided these two issues. क्या decide किया? That not barred by law and Indian contract applies. Indian contract applies, or it is governed by Indian contract. These two issues have been decided. So A and B file a suit. A file a suit against B for a breach of contract. Parties decided. Court frames the issues. They frame four issues: whether the Indian contract will apply or not, whether it is barred by law of limitation or not, do there is a breach of contract or not, do they have a contract or not, whether करके it is normally framed whether. ठीक है. अब now these issues are already been decided, but B in letter stage. When I say letter stage, somewhere after argument or anything, so these issues are decided, and B in letter stage want to raise same issue. Want to raise same issue again. Can he do so? Answer is not allowed. Not allowed. Section 11 applies. Section 11 says it no court shall try any suit or issue. That means issue which is decided by primarily, which is the issue which have been first decided once, cannot be raised again. So it applies upon issue. How they will be decided, वो भी हम पढ़ेंगे आगे. I'm focusing upon that section 11 says no court shall try. That court is not allowed to try either the suit which is decided or the issue which is decided. So I have taken example issue decided within the suit only. For example, I am having a suit with B. Some issues are decided by the court primarily, and I want to raise objections. I want to raise those issues again. I am not allowed to raise those issues again if they have been decided once. So decided once cannot be raised again. Understand the concept of issue? Any question regarding this, the suit and issue? The two things we have done. The no court shall try any suit or issue. Next, they are saying any suit or issue in which the matter directly and substantially issue has been. This is what they're saying. Another third perspective is matter directly in issue. Matter directly and substantially in issue. When I say matter directly and substantially, you should try to understand what they're saying. I'm reading again. You people please focus upon the bigger act so that I can make it more clear to you. No court shall try any suit or issue in which matter directly and substantially in issue has been directly and substantially in issue in former suit. They're saying matter directly and substantially in issue in former suit. What does it mean? This is this. What do you mean matter directly and substantially in issue? Now we will Ayush, we will come on this part also. If new fact has been arised. So whether it be issue be allowed or not, we will come to that. Don't worry. यहीं पे आएंगे matter directly and substantially. So what they are saying, try to understand again. They are saying court is not allowed to decide suit or issue. Which type? This is this line explain the nature. This is which suit or which issue you cannot be allowed to decide again. Try to understand. They are saying, firstly, they say court will not try any suit and issue. And in later stage, they're saying what should be the nature of that issue or the suit which will not be allowed to rethink or reopen again. This is only those issues which were directly and substantially in issue former suit will not be allowed to reopen in the next suit. Now, important is what do you mean by matter directly and substantially? To understand matter directly and substantially in issue, we have to see explanation 3 and explanation 4 of section 11. So we'll go into this, don't worry. Try to understand again. Very important. Matter directly and substantially in issue. What does this line says? This line focuses upon the nature. What they are saying, they say we are not saying you cannot decide any issue again. This res judicata does not apply upon every issue you decide. So suppose I decided 1000 issues. This is not 1000 issues. Out of those 1000 issues, the issues which were directly and substantially issue in the former suit, and they are also directly and substantially issue in the present suit. If this is the situation, then I am not allowed to raise. I am not allowed to decide it. For example, let us first try to understand what do you mean by matter directly and substantially in issue. So let us explanation 3 and try to understand what do you mean by matter directly and substantially in issue. So explanation 3, tell us what are the matters directly and substantially in issue. Let me read this section. Explanation 3. This is the matter above referred. It must be the former suit have been alleged by one party and either denied or admitted expressly or impliedly by another party. What they are saying, what do you mean by matter in issue? This is issues alleged by one party and denied or admitted by other parties. This is they are matter directly in issue. Matter directly and substantially in issue. So what they are saying, what do you mean by matter directly and substantially in issue? This is वो सारे matter which was decided by the court in previous suit, and those matters were alleged by one. When I say alleged by one party, that means the facts which were disputed, the fact which was disputed by one party, and the other party either admit those facts or deny those facts. There's a none matter. For example, let us pick up example. Again, let us pick up example of a breach of contract. Breach of contract between A and B. Court decided. So let us, before deciding it, let us create. Issues were framed. Issues were framed. What were the issues? Whether contract or not. Whether contract or not. Second, whether breach of contract or not. Whether breach of contract or not. Third, whether breach of contract or not. Third, amount of compensation. Amount of compensation. These were the issues framed. And while deciding this issue, कोर्ट डिसाइड आल्सो, कोर्ट ने फाइंड किया फर्स्ट, they find that they find finding of the court, let me say finding of the court, finding of the court is A and B are friends. Second, A and B make a contract. C, third issue, B always have faith on A. 4, A made a breach of contract. A made a breach of contract. Suppose these are the observation of the court. Ab you tell me, out of these 4 observations, which observations are important to decide matter and issues? Which of the observations are very important, are required to decide the matter in question? Their friend, is it important? Not. Whether A and B are friend or not important. What is the requirement? A make a contract, yes, this is important. They always have a faith upon, no, not important, but yes, this is important. 2 and 4 are important, whereas 2 and 3 are not important. Court decided all 4, but out of this, these 4 will be considered as matter directly and substantially in issue, right? So out of these, so what do you mean by matter directly and substantial in issue? Those questions which are necessary, or those facts which were necessary in order to decide the matter in dispute, and out of these, one party alleged that fact and another party denied or admitted that fact, will be considered as matter directly and substantially in issue. Firstly, right? Apart from the, so suppose now again, second suit, let us be second suit second between A and B only, because same parties भी होता है, so let it be A and B only. Suit is whether A commits breach of trust, whether A commits breach of trust, और इसके अंदर एक इशू आया, इशू डिसाइड कर रहा है, कोर्ट इज डिसाइडिंग इशू that B have trust on A. A raised the objection. A raised the objection that cannot decide the issue as already decided in previous suit. So this is something already been decided. So whether A trust, so suppose ना, देखो ना, they are, we always have a trust upon decided, this is issue already been decided. So A is saying you cannot decide it again because this issue has already been decided between me and A. A is saying that this issue is again already been decided between me and B in suit number 1. So how can you decide this same issue again in suit number 2? And he applies for RJ. He pleads RJ. Can he plead so? Will res judicata apply or not? Will res judicata apply or not? Try to understand. This is already been decided, and they're saying that we have already decided, and now why? How you can do it again? Answer is res judicata will not apply. Why it will not be applying? Because section 11 says res judicata only applies upon those issues which were directly and substantially in issue in a former suit. And now try to understand in a former suit when this was decided that we always trusted upon A, we have a faith upon A. That time this issue was not directly in matter in this in that suit. Rather in suit 2 this matter is directly in issue. So obviously res judicata will not apply. So try to understand. Now you should got your answer. Res judicata does not apply on each issue. It applies only upon those issues which were previously decided by the court and in a previous matter in which they was decided. They were important, substantial questions. They were directly in issue. And now again, in the present suit in which the question of res judicata is being raised, they are also being decided. They also be directly and substantial issue. So in previous suit also, they were directly and substantial issue, and in this present suit also, they are directly and substantial. In both the matter, they were directly and substantial in issue. Then only this will act as res judicata for this. So if this is a primary first suit, इसमें जो the issues decided in this suit will act as res judicata for this suit only. Firstly, they are directly and substantially in this suit, that is alleged by one party and denied by another party. Firstly, and the issues are also being directly and substantially in this suit, alleged by one party and denied by another party. So that means uh, uh, both the suit, both suit must have the issues directly and substantially in issue in order to make them act as res judicata. So they will become res judicata only when they were directly and substantially in a primary suit, previous suit, and now in secondary suit they again are directly and substantially in issue. This is the first condition. We will add on condition. Parties must be same. Okay, that is also very important. This much is clear. This much is clear, right? Let me do. The one thing is first perspective we have to understand what do you mean by directly and substantial in issue. Sir. Ayushi, I will come to that topic. Just wait a bit. The directly and substantial issue we have done first part, which are being raised by one party and which are alleged or denied by other party. My next question is issues are not being raised by the party. Can those issues which was not raised by the party in a previous suit, issues not raised by parties in previous suit, raised in next suit, raised in subsequent suit? Try to understand. In previous suit, parties have failed to raise those questions, and now in subsequent suit they are raising it question. Can such issues act as res judicata? Can such issues act as RJ, res judicata? Can such issue be act as res judicata? Answer is yes. Even such issues can also act as res judicata. Answer is given under explanation 4. So constructive, try to understand. Directly and substantially in issue have two parts. One part, matter has been directly raised by the parties. They were alleged by one party, denied by another parties, and matter directly and substantially in issue. Secondly, matter may be directly and substantially in issue where though party have failed to raise them, but parties were either might or ought to be raised. So let us read explanation 4 and we come to this part also. Any matter which might and ought to have been made ground of defense or attack in such form of suit shall be deemed to have been a matter directly substantial in issue in such suit. Section 4 is known this explanation 4 is known as Constructive res judicata. What do you mean by constructive res judicata? Try to understand. They are saying there is a suit. Suit 1, parties have raised 1 issue, 2 issue, 3 issue, 4 issue, and out of this there are 1, 2, 3 party ought to raise. What do you mean by ought to raise? Ought to raise का मतलब है party have a duty. Party knows. The party was aware about these facts and they does not plead it. Okay, duty to raise, fail to raise. So section 7 explanation 4 is saying ought or might to be raised. When they says ought to be raised, matlab, the parties were aware about the facts, they have to raise it, but they fail to raise it. Or might to raise. Might to raise means party with due diligence may discover sort the facts. The party with due diligence may discover. So party with due diligence may discover the facts. They can do those, but they does not apply their due diligence and they does not make such discoveries. And therefore, what happened? They failed to raise these issues in suit 1. So what happened in suit 1? Parties either knowingly fail or knowingly does not raise. They ought to raise, but they were duty bound to raise. They were aware about the fact and they have to raise them, but they fail to this. They does not raise it, or they might raise it with the due diligence, with the reasonable caution. If they have applied their reasonable caution, they might raise it, but still they fails to do so. And now what happened? Now in second suit, in suit 2, now they are raising these 3 issues. Now raising in 2019, and this is already decided in 2010. Decided. So this issue has already been decided in 2010, and at that time they were aware about these facts. Or if they are not aware, they may raise it, but they does not do. They does not apply it reasonably. Now they are coming with, and they are applying in 2019. So explanation 4 says it is your mistake. Your mistake not to raise, and we will presume that we decide the issues. We presume that issue decided, and RJ applies. RJ applies. That means now you cannot raise issues again. So this is matter directly and substantial issue. The matter directly and substantial in issue have 2 phases. One is that party raised it and court decided, and party raised it and other party objected it. They all are matter directly and substantial issue. Secondly, party might or ought raise it, but they fail to do so and not been decided by the court. Still, they will act as res judicata upon the party who was duty bound to raise those issues. Okay. Court will not try. Court will not try. So section 11 says that no court shall try. So this says no court shall try means present court. They says whenever a suit come into the court, it will not try the suit or an issue if that suit or issue is already being decided by previously by other court. Who is other court? We will study that. By other court in which the matter in the present court, was also the matter in the previous court, and like this matter, it was there also, directly and substantially an issue, right? Then this court, this secondary court, the court which is having a subsequent suit, will not decide the matter. Till now, we will add on the factors. So we have added 2 factors: matter directly and substantially an issue. It applies upon suit and issues, and bar is upon the trial. Let us make an add-on to this. I'm again reading section 11, and we make an add-on to this. No court shall try suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties. And this is the third condition. The issue must be between the same parties. This is the fourth situation. Same parties. Or between parties under whom they or any of them claim litigating under the same title. Or parties litigating under same title. And this is the fourth. We will understand the word title also, but first of all we understand the meaning of same parties. What they are saying, this says that in order to apply res judicata, the party in a first suit must be same in that of second suit. So suppose in 2010 the parties were A and B. In 2019 also they must be A and B. This is a basic. We will change the situations. What the basic terminology says that in order to apply res judicata, one thing is to be seen that the party in the former suit and the party in the present suit upon which you are going to apply, that is subsequent suit, upon which you are going to apply the res judicata, they both are same. But try to understand, what do you mean by same? What do you mean by same parties? In this suit, suppose this is suit in 2010. A is a plaintiff, B is a defendant. And in 2019, same suit. Now, because we have understand, so we will keep other objectives same. In order to understand this portion, we will keep the suit is same. Matter is directly a substantial issue. Right. So other ingredients are same. Now let us apply this fourth ingredient. What happened? B is a plaintiff and A is a defendant. So what has happened? In earlier suit, A was a plaintiff, B was a defendant. In a present suit, B is a plaintiff, A is a defendant. बताइए, do res judicata apply or not? Other features are same. Do res judicata apply or not? Do or parties have changed? देखिए, same parties does not mean same position. So it is not necessary that earlier suit mein one was the plaintiff and therefore in this suit also the other was the plaintiff. No, same parties mean parties must be same, whether they are acting as defendant or plaintiff or otherwise. Understand? The parties must be same. So it will not affect whether A was plaintiff at that time, he is not plaintiff in this suit. This is not going to affect. Firstly, this is what you mean by same parties. Another issue they are saying, or between parties whom they or any of them claim litigating under the same title. Try to understand. Litigating under the same title. Let us pick up the example. In 2000, एक suit है. This is a suit one between A and B, decided in 1986. A dies, X son of A. ठीक है, X dies and it is a son of A जिसको प्रॉपर्टी चली गई, and B dies और इसका सन कौन है? Y is son of B. Now in 2019, suit is being filed between X and Y. Other things are same suit, same ingredient, everything is same, directly and substantially in issue. Okay, now but the suit is filed between X and Y. Will res judicata apply or not? Earlier suit was between A and B. Now the suit is between X and Y. Will the res judicata apply or not? Answer is yes, it will apply. What do you mean by? What if there is a addition in another party C to A and B, and previously it was A versus B, now it's AC. We will come to that, don't worry. I will come to that topic also. First of all, yes, answer is this to this question is this, that yes, res judicata will apply. Res judicata will apply upon the parties, right? So this is because they are litigating under the same title. They are litigating under the same title. One question is this: suppose A and B have a suit. One more question. We will come to another question. Suit 1. A and B have a suit decided in 2000. Decided in 2000 in favor of A. In favor of A. In favor of A. A sells the property. A sells the property to T. What has A has sold the property to T. A suit 2 has been filed between T and B is dead. Dead. Son Y. There is a son Y. B is dead and there is a son Y. Suit is filed between T and Y. बताइए. Suit is filed between T and Y. Other things are same. Suit 2 has been filed between 2 and Y in 2010. Will the res judicata apply or not? Other things are same. Other ingredients are fulfilled. Answer is res judicata will apply. Parties litigating under the same title. So same titles means either the LR or any other person has come into the shoe of the plaintiff or defendant. So who were the parties at that time in first suit? It is not necessary that they will be only the party, or it is not also necessary that in earlier suit one was the plaintiff, then other also should be the plaintiff in other second suit. No, he may be a defendant. It does not matter. What is important, they were the same parties or party litigating under the same title. That is, the person now fighting is fighting for in the same shoes as the earlier party. So T is fighting into the shoe of A, though the name is being changed, but the shoe, the cap he is wearing is the cap of A only. So he's a party litigating under the same title. Right. Another situation is this. Suppose suit 1 is there and there is a suit 1. A and B decided 2010, and there is now suit 2, and suit is A, C versus B. Other things are same. But earlier C was not the party. Now C has been added by the party. Other things are same. Will res judicata apply or not? Now other things are same. Marriage and everything is same. Will res judicata apply or not? Answer lies into the fact. If C is a necessary party or proper party. If C is a necessary or proper party, answer is RJ not applies. Yeah. If A or C is a necessary party and he was not previously added, rather now he is added. So what the other suit will not apply as res judicata. But yes, C was not necessary or proper party, normal party. Now his presence will not affect res judicata will apply. Otherwise, RJ applies. So remember this. Suppose the third party is being added and everything is same, and third party is added, which was not available in earlier suit when decided, and this party is a necessary party or a proper party, then yes, res judicata will not apply. Rather, the second suit has to be tried, because you cannot defeat no law. Res judicata is a doctrine of procedural law. So no procedural law can defeat your substantive right. So necessary parties and proper parties have a substantive right to decide their matters, and therefore no procedural law can defeat substantive right. Whereas suppose C is not a necessary party or proper party, rather any party, regular party, I will say, okay, there whose presence may or may not be affected, then yes, res judicata will apply and second suit will not be allowed. Right. We have done with the concept of same parties. We have done with the concept directly and substantial in issue. Is C is a necessary party, then res judicata will not apply. Yes, exactly, Ayushi. Okay, sir, can you please explain the last example again for necessary party. Exactly, Raya. What I'm saying, what we have done, that there is a suit one which is between A and B, and this is decided in 2010, suppose. Now suit 2 is being filed, other conditions are fulfilled, matter and issue, everything is fulfilled. But in suit 2, what has happened? A and another party has been added, either as a plaintiff or a defendant. A versus B and C, doesn't matter. Added as a plaintiff or a defendant, doesn't matter. This C is present. Will it affect the jurisdiction? What is the effect? I says if C is a proper party or necessary parties. The proper parties, necessary parties are those parties whose presence is mandatory. If they are not present, the decision will become infectious, or decision will not be an effective decision, or it will not be considered as a decision on the basis of merits. It will not be considered a decision on the basis of merit. So C is a proper or necessary parties. If yes, then no RJ apply. So res judicata will not be applied, rather suit 2 will be decided, because C have substantial right into that. But yes, if C is not a party, necessary or a proper party, then obviously res judicata will not apply. So else res judicata will apply, sorry, else RJ will apply. So if they are proper party or necessary party, res judicata will not apply. If they are not proper parties or regular parties, so RJ will apply, right? So let us read further. Obviously, I need so much on this. So whenever I take my normal classes, I take 20 days, like approximately 40 hours to explain res judicata. But instead, I have tried my best to complete it 1 hour or 1 hour. I will take 10 to 15 minutes extra also. But I will make you complete clear with the concept, basic concept of res judicata. Res judicata is very broad also, but I can make you clear with the concept to that extent that if you read some parallel book, it will be very much clear to you. Let us read again. I am reading again the whole section. No court shall try. We have done this. Any suits or issue, we have done this. Which the matter directly and substantially in issue, we have done this. Has been directly and substantially in issue in a former suit between the same parties or parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit in which such issue has been subsequently raised and has been heard and finally decided by such. Heard and finally decided. This is what I want to explain. Last point that I want to explain is very important. Heard and finally decided. This is the fifth test to apply. We have so many tests of application of res judicata. We have to check all these. Okay, we have to do all these. Heard and finally decide. Heard and finally decide means on marriage. In order to make suit 1 RJ to suit 2, in order to make suit 1 and RJ for a suit 2, you must see one thing, and what is that? That the suit 1 must be decided on the basis of marriage. It must be decided and here. That means suit 1 must be decided on the basis of marriage. If it is not being done on the basis of marriage, then it will not act as res judicata. Okay. Now this is very important. Heard and finally decided means the former suit, the primary earlier suit, must be decided on the basis of res judicata, on the basis of marriage. Or heard and finally decided. So what happens? Suppose suit 1 is there, suit 1 is there, and court issue temporary injunction. Right, there is a suit 1 who is issued temporary injunction. this applies upon issues also. So suppose in a suit 1 the issue has been decided, temporary injunction, and in suit 1 only, later stage, application to set aside temporary injunctions comes. Can we allow this or not? Can we allow this or not? Answer is yes, because temporary injunctions are not something which is heard and finally decided. They are not heard and finally decided on merits. So they will never act as res judicata. So you can challenge them anytime. Similarly, ex parte proceeding. So generally, ex parte proceedings, I cannot explain right now, but ex parte proceedings are two process. If ex parte proceeding is not on the basis of merits, so yes, they can be challenged. So generally, ex parte proceedings are not on the basis of merits and does not apply res judicata. But in a such, there are certain conditions where they are considered as on the merits. So some, for example, I can just explain in a bit on that part. Suppose the other party is not coming and court proceed ex parte, and how it is proceeded, it has just struck the right of defense. Just they have struck the right of defense, but they have taken the evidence of plaintiff completely. Then such type of degree will be considered a degree on merits. But suppose they have not only struck the defense, rather they simply declared the judgment in the favor of plaintiff merely on the ground because defendant is absent. Then such type of ex parte degrees are not considered as on merits, and they will not act as res judicata. Right? Shish. So if there is a suit 1 in which 4 issues have been framed, 2 were decided and 2 were not decided. So sir, second suit, the rest second issues which was not decided in previous suit can be done in subsequent suit if the issues are same in the previous and subsequent. We will come on this. This is an explanation 4. We will come to this issue explanation 5. After this, I will explain this. Okay. So heard and finally decided. You have understand? Heard and finally decided. Right. I will read last explanation 5, which is important. Which Varshney has asked me, Ashish has asked me the question also, and I want to read explanation 5 for you. What this is: any relief claimed in the plaint, which is not expressly granted by the decree, shall be, for the purpose of this section, be deemed have been refused. What they say, what they saying? What they are saying? If suppose parties have asked certain reliefs, they have been made, and out of that, court has given certain reliefs, and on certain relief, court has neither denied them. The parties have asked so many reliefs, and out of them, some has been rejected by the court, some have been awarded by the court, and upon some, the court is either silent, neither it has awarded them, neither it have rejected them. Then in such situation, it will be presumed, as per explanation 5, that court has rejected your relief, and you cannot reclaim such relief again. Right? Ayush, can you explain again the application remove temporary injunction? Ayushi, temporary injunction application does not come under res judicata. Why? Because it is something which is not heard and finally decided. So anything which is not heard and finally decided will not come into the purview of res